and you have these two little kangaroo courts going on, and the parents go in there and they say, well, now you got to do this, you got to take this parent training course, and the judges often get kickbacks. That's what they don't tell you.
That's crazy. I tell you.
This is nuts. You put a parent, you got to go with this thing, and you got to pay to go through this
no.
thing.
I mean, it's bad. I mean, the open.
This is how they took, and you know.
The open courts are bad enough.
Betty Powers, she had no chance. She had no chance. And the weird thing, another judge in Ventura County had just given Betty Powers 50% custody of her two sons, who were about 9 and 10 at the time, and at the same month, they take away her baby daughter, the only daughter she ever had.
That's weird.
And she had
so wait, you're saying they said it was okay for her to have her older boys, but then she couldn't have her daughter.
Her newborn daughter.
Why did they say that?
Because the system is corrupt, and the two boys looked a little more black than most kids. They looked a little darker, and they're hard to adopt out. The father had full custody, and when he got trouble with his new girlfriend, he said, hey, judge, give her 50% so she can take the kids for the summer. So the judge said, fine, I give her 50% custody. She did wonderful. I videotaped her playing with the kids appropriately in the park. She prepared an apartment, and in the apartment she got a crib. She got everything she needed to bring the baby home before she had the baby. But CPS went into Marion Hospital without a warrant, without a hearing, and they knew she was going to have this baby. And they knew she was going to have this baby, and they could have had a hearing before she gave birth to the baby and put the evidence in front of the judge. But they had no evidence.
That's awful.
And they grabbed her baby out of Marion Hospital, the old one, before they built the new one, and kidnapped that child under color of law. And she had just got custody of her other two sons.
So we had a judge make a determination that she could have her sons, but then a
different judge said you can't have your daughter because we can't hold the CPS workers responsible for unlawfully kidnapping.
Didn't they try and put the evidence from the other case in front? I mean, you know.
She had a public defender who sold her down the river right at the get-go. The first thing you need to know, if they grab your child, you put in your demand for a jury trial of parents. Under this special clause, you have a right to have a jury made up of parents.
Uh-huh. Wow.
Most parents don't know that, and they're just so upset. They took my kid. They took my kid.
You're saying the public defenders, the first thing they do is waive that?
Waive your right to a jury trial, not just an ordinary jury. We might get single moms, or you might get people who have never been a parent. Well, you get a jury with parents.
And I would like to pipe in for a second. I've dealt with public defenders. I mean, I've actually researched them pretty thoroughly, and I don't want to go too far off what you're talking about. But yeah, public defenders are pretty pathetic at best. There was a great case that was decided, I think in the 1840s, about whether or not the federal government should allow public defenders. And they actually went back to the debates in Congress, and they said it was a mark of tyranny to finance both the prosecution and defense of a crime.
What year was this?
It was. I think it was the 1860s when this decision was made. And it was Pennsylvania. They were going to be granted the first federal public defender, and somebody challenged whether or not having public defenders was right because they were financed by the federal government. And they said, well, that's kind of a conflict if you're also paying for the prosecution. And so the U.S. Supreme Court took the issue up, and it was talked about in this case called Ferry versus Ackerman, and another one called Tower versus Glover. And they looked at these cases and they went back and they said in Congress, and it was in the 1820s, I think, they said it was a mark of tyranny to be both to finance both the prosecution and the defense of a crime. So when you see a lot of people going before public defenders, they're next to worthless in a lot of cases. I mean, one of the most basic things you should demand in any trial, whether what you're talking in your child cases that you're talking about, or even a criminal case, is discovery. I can look at everybody. I don't care if you're Charles Manson or Betty Boop. You know, if you get accused of a crime or anything else, you should have a one-page discovery motion filed on your behalf. And I guarantee you, if you sat down, and I don't care who you are, with no technical understanding of the law, you should be able to go and look at anybody's file, and you'll find out public defenders don't even file discovery. They don't do anything for these people. They have a mandate to act competently, and yet
they can't.
And yet they don't.
They don't, or they can't, because they have too many cases and they're underfunded.
And I don't know if it's intentional or if they're stupid or if they don't know what the hell they're doing. They just appointed this guy named Montes de Oca to be the head public defender. I met the guy. I don't think, I wonder how he can walk upright. You know, for anybody, you know, Montes Doc, if you're watching, I think you're that stupid. I really do. I've seen you. It's embarrassing. And yet, if you're accused of a crime, even if you didn't do it, this is the guy who's going to be representing you. Yeah, he can bring a slander case against me.
He said it.
I'll take him. I don't care.
I haven't met the guy.
Shameful.
So
I'll go in front of the Board of Supervisors and I'll tell them too. Because that's the caliber. Listen, we'll put the really sharp prosecutors in there, and we'll put some, you know, either.
Well, look, we had this nincompoop, totally lacking in brains, named Meg Nicola. He was allowed in the Michael Jackson case in 2005 a half a day, and he had weeks to prepare the evidence, and it was to prove that Michael was engaged in a phone conspiracy to kill the Arvizio family. And he put the charge up, and they had, you know, one witness say, yeah, this is what, and they call this person, and Michael called that person, and they were going to get a helium balloon and take their visors up over the forest and throw them out. And Michael's not even capable, like Tom Mesros. He's not even capable of thinking like that.
Yeah.
But he had a half a day, and then they put their own prosecution witness on, and he looks at, and he works in some capacity for the county. He looks at the chart and he says, and Meg says, "No, this is all correct, right?" And right?
Yeah. Yeah.
And he was supposed to lie and say, "Yes, Mr. Meg Nicola, this is all correct." And the guy said, "Nope, you got it all wrong." So he had weeks to prepare, and he screwed this up. Meg Nicola should be disbarred.
Yeah.
Ron Zonin should be disbarred. Gordon Auchincloss should be disbarred. And together with Tom Sneddon, they should all be serving time in prison for fabricating evidence. But that's
I think that's
8 years back.
I think fabricating evidence is standard procedure anymore.
It is.
I mean,
standard procedure.
You know, I mean, it's embarrassing. You know, and for anybody who wants to doubt whether or not we can say these things, there's a great case, New York Times versus Sullivan, where, you know, they gave people the First Amendment rights to come out and just say it, and the standard is malice. You know, we're not being malicious. These are our opinions. And the funny thing is, if you go to network TV, you won't see people say this. You won't see people question it. You won't see people dig into cases and look at the citations or question their procedures. You're not supposed to do that. You're supposed to see, it's almost like the media wants everybody to think everything's on the up and up. You know, I see TV shows like CSI or Law and Order, you know, and it's hilarious. I mean, I don't mean to belittle this thing, but, you know, we need to. You know, when they say, well, we don't have enough evidence to bring them in. What are you talking about? I mean, the cops grab people. I mean, on a random basis. They'll make evidence. I mean, prosecutions are a sham, and I almost think that they have, you know, let's go back.
This is the Kelly Thomas.
Let's go.
Beat Kelly Thomas to death, and then they made evidence.
Let's go back.
And then they discovered, oh my God, there was a video cam in the bus and at the bus station. Now we got to rip up our sworn police statements and we got to rewrite them because we'll be caught in our perjury. And the cops. And what's wrong with that stinking Tony Rakalkas of Orange County, California? He is not pressing charges for first-degree premeditated murder against the 3 cops that held him down and beat the crap till they killed him, and they're not getting the other 3 cops for accessory to murder.
Yeah,
and they postponed the trial.
Yeah.
Even of the minor charges, they put the 2 cops on. I'm thinking.
Or how about the?
What if we did that to cops?
Oh, I know. You know, yeah.
And just beat the crap out of the cops until we killed them. We got 6 citizens that grabbed this cop. He's a bad. Now we'll just beat him to death. Oh wait, we got caught on video. We got to change our story.
Look at that.
You think they wouldn't give us first-degree murder?
Yeah.
We would be put away. And then we'd be hung.
You look at that case that they had a couple years ago in the light rail up north near Oakland, and the guy,
Oscar.
Yeah, they
murdered Oscar.
Six guys were holding him down, and he pulled out a gun and shot him in the back, and it was on video everywhere.
Everybody had it. It's on my YouTube channel.
Yeah, and it was crazy, and in the end, he got something like 4 years with 2 years suspended, and I mean,
and he even escaped to Nevada, trying to escape capture. This was a BART police officer. Then he had just had a baby born the day after he killed Oscar. He fled to Nevada. They went after him and said, "Hey, we're going to give you a low time. You're going to walk down easy street. Come on back." So he turns himself into Nevada. He comes back. He's now out of jail. He's done. He had his trial. He served his 2. And now compare this. Compare this to Mr. Mack. Mr. Mack, Darren Mack, who didn't kill the judge by his own testimony. He could have if he wanted to, but he only winged him because he was screwing his divorcing ex-wife while he was ordering him to pay his wife, I think, $20,000 a month for one child support. But he did kill the wife in a fit of passion. So he killed one person. He's now serving life in prison in Nevada without possibility of parole because he dared to appeal it after his first attorney screwed him into 20 years, where if he had shut his mouth, started doing the 20, he might have got out in 10.
Well, basically what we're saying is there's a two-tier system of justice.
There's no justice there's no equal justice.
If you're a cop, or if you're somebody,
or you're an attorney,
or if you're somebody in the government, you will be given not only favorable treatment. You'll get softer charges. You know, the man who shot the person in the
Chandra Levy.
Well, wait.
Remember, saw, we got him on tape.
We saw Condit. Gary Condit.
Gary Condit is back working in the legislature. Who the hell hired this ex-congressman who's probably got something to do with the murder of what's her name?
Chandra Levy.
Chandra Levy.
And they found a Mexican guy that they said he did it, and then now there's a habeas corpus going on whether or not questioning
Well, the Mexican didn't do it. They just
needed
to take the attention off of Gary, what's his name?
Condit,
who used to be a congressman from Modesto,
the Bay Area, north.
Modesto area, somewhere up north, and we saw him going into the same hearing room.
The audit committee.
The audit committee met in, and here's what's funny, and I can show you this on tape next week. I'm not ready because we have so much to tell you. They had another hearing right after this hearing with 100 parents trailing in. They're saying, audit the C.P.S. statewide. The next hearing, there was only 2 or 3 people listening. Half the senators that were supposed to be in that hearing didn't even show up.
Yeah.
And nobody was in the hallway. And it had to be with the use of Measure B hospital funds. A very important issue. But nobody cared. Nobody showed up. This issue, stealing, kidnapping under color of law, which CPS does every day, day after day, it's routine. We need these people to be facing a special grand jury. Now, Mike's going to argue with me, okay? He's going to play devil's advocate. I say the special grand jury should be in every county, appointed by not the local judges, not the friends of CPS. They should be appointed by a special ombudsman, and the special indictment grand jury to indict CPS workers should be made up of victims, non-custodial parents, especially those that belong to Fathers for Justice and have been screwed out of seeing their children and forced to pay child support while somebody's molesting their child or their son or daughter, but they can't even visit their son or daughter. But some boyfriend of the ex-wife can molest them or rape them or do whatever. These people who have been so badly abused should be on that special grand jury. Now, I say they should not be able to bring up their own case, but they should be able to hear the evidence from other victims of CPS who had the same CPS workers as they did, had the same criminal, rotten to the core judges in family court that operate star chamber proceedings.
Yeah.
Now, Michael disagrees with me.
Well, one of the main tenets to a grand jury, if you're going to indict, is somebody's got to be neutral. And I do at least, what you're saying about Child Protective Services. Anybody who had their own personal experience with, any government actor who harmed them in any capacity, the grand jury should take evidence from them, but it shouldn't be necessarily, the idea is that the grand jury is supposed to be, common citizens, and when they come up with an indictment, what that's supposed to be is probable cause. And that gives the prosecutors the ability to, go in and actually start the prosecution. I don't think those happen anymore. I don't think we even have
They don't happen anymore. And guess what? Who appoints most grand juries is the county judge, right?
Yeah.
It's a county judge.
It's the presiding judge usually.
A presiding judge, and he used to be one of those family court judges most likely, and his buddy judges are the guys that are going to be hauled on the carpet. They're pretty little girlfriend faces that are probably bumping in the back chambers. These CPS workers, whether they're pretty or not, are friends of the judges. They help ensure the judges' pension files by screwing somebody out of their kid and then getting federal matching funds. So they're all dirty together.